They appear both as an office and as an individual charged with responsibility. And there is growing concern that the police and people in authority are behaving as though they are not subject to the law. Once the court summons an individual, that individual has to present themselves in person. They can then seek to be excused by the court. Failure to appear is actually disobedience of a court order.
Yes.
And counsel cannot waive the personal appearance of the Inspector General of the police. It's not too long ago when Inspector Masengeli failed to appear for quite a number of days. We are urging the court to assert its authority for the sake of putting a stamp on upholding the rule of law. Let Inspector Kanja, if that is his rank, I call him Inspector General so that I do not mistake his rank. Let him appear in person, excuse himself, so that the court may have the discretion to either hear from him or from a third party. If you allow me, and the court has already observed it,
Yes.
that habeas corpus is one writ that protects life and liberty. And when the court orders for the production, the writ is not spent. It is for whoever is holding to come and tell the court, yes, we have the person, or no, we don't have the person, and explain. And we will be able to converse before the court that it is the business of the police to know everything security. So it does not suffice to actually excuse the IG in his absence. We are urging the court that the people entrusted the authority in the court of arbitrating between citizens and those who are wielding power. The Inspector General, on behalf of the police, is wielding powers of arrest, powers of detention, powers of knowing everything security. Let him come and answer the complaints of the citizens filed by the Law Society. Yes, and I will rest the matter there and request that my learned friend and senior in admission, Stephen Kalonzo adds something.
My Lord, just to add to what Senior Counsel Mother said, these are matters of great national, I want to add international concern, because matters to do with human rights are universal.
Yes.
So, my Lord, you issued specific orders yesterday.
Yes.
Non-compliance should be met with penal consequences. At a time
Yes.
at a time when the nation is celebrating the end of the year,
Yes.
it is unacceptable that there will be blatant abuse of human rights,
Yes.
and the country is expected just to slide over into the new. So I urge, my Lord,
Yes.
that penal consequences and accompany your specific orders yesterday.
Yes.
With the permission of the court, I'll ask Counsel Zero Ndegwa to conclude that was that response to what the State Council said.
My Lord, with respect to joinder, the ninth respondent,
Yes.
he is enjoined in his own capacity. He is not before you to contest his joinder before you. He has not sent counsel to come and contest that joinder in that particular individual capacity. And therefore that question has not been posed, or that challenge has not substantively been posed to the court for determination by the respondent. Additionally, my Lord, looking at Article 245, as read together with Section 8 of the National Police Service Act,
Yes.
the holder of that office is an individual.
Yes.
And Section 8 provides that the service shall be under the overall and independent command of the Inspector General, appointed in accordance to Article 248 or 245.
Yes.
My Lord, in the absence of the respondent, all what my Lord can be read into is that he is in contempt of your orders. And for the question of contempt, my Lord, can only be addressed by the contemnor.
Yes.
By the fact that my lord and senior Mr. Nyamondi is present, representing the IG, it's prima facie evidence of the knowledge of service of that order on the part of the ninth respondent.
Yes.
And as indicated by my lord and senior counsel, and my lord, I'm informed by the LSK that there is an affidavit of service of record
Yes. Dated 30th
dated 30th of
December
December.
2024. I have looked at that affidavit of service. I am satisfied that it complies with Order 5, Rule 22B of the Civil Procedure Rules in terms of electronic service. Yes, Mr. Njiro, anything else to add?
Only to add that, my lord, that the said respondent be held to be in contempt of the orders. And that we cannot proceed until that contempt is purged by the contemnor. This is a very grievous matter under Article 25.
Yes.
Article 25, as we all know, is a non-derogable article.
Thank you, Council. I think you have
Yes, my lord.
you've not strayed into arguing.
That's correct. Permit me to invite the LSK to be first at point.
Yes, Council, any question right now?